Assalamualaikum and greetings to Dr. Muhammad Chin. Today, I will be presenting my individual assignment HRM659 Industrial Relations on the reflective current issues based on the two topic givens. So, the topic given is constructive dismissal in Malaysia. What should you do when your employer is trying to force you to resign? And the second one is the effect of soft skills on Gen Z's industrial relations in Malaysia. So these are the two topics that I will be presenting about. So what is constructive dismissal? Constructive dismissal occurs when an employer's action creates an intolerable working environment, effectively forcing an employee to resign. This is considered a breach of contract. Even though the employee formally resigned, it can be treated as a dismissal. So, for the first topic, constructive dismissal, I have chosen the article from New Straits Times, and the titles are Asia ordered to pay 268,620 ringgit to an ex-pilot for constructive dismissal. The article link is given below. Let's talk about the issue based on the article. Due to constructive dismissal, Asia has been ordered to reimburse the former pilot 268,620 in compensation and back salary. The pilot joined the airline in July 2018 and left in 2022 after being placed on leave because of the COVID-19 pandemic. The airline reduced the pilot's base salary by 75%, and during this period, they claimed that the border constraint that resulted in halt aircraft as the reason. So, the statutory law that applied to this article is, under Section 20 of the Industrial Relations Act 1967, any workman who says he has been terminated without just can file claims in the Industrial Relations Department for reinstatement within 60 days of the termination. In the context of constructive dismissal, the termination date is the resignation date. So, this is because of the intolerable working conditions. The employer's action must render the working conditions to unacceptable that the employee has no reasonable choice but to resign. Okay, so let's go to the next article. The next article that I choose is also from New Straits Times, where the title is, the company told to pay 66,000 for constructive dismissal of employee of a pregnant woman. The link is given below. The issue based on the article that I choose, the company was ordered to pay 66,000 in compensation to a former employee for constructive dismissal, ruling that her employer took action designed to force her out of her job during her pregnancy. The industrial court found the employer used tactic to make the employee leave her position as an assistant office administrator despite her pregnancy and related health issues. So the statutory law that can be applied to this situation is, under Section 41A of the Employment Act 1955, protects pregnant female employees and those suffering from pregnancy-related illness from termination, unless there are specific grounds like a breach of contract, misconduct, or business closure. Meaning that if an employer treats a pregnant employee unfairly, making her working conditions intolerable, she could argue for constructive dismissal. These could include unfair changes to duties, ignoring requests for adjustment due to pregnancy, or generally creating hostile environment. So let's go for the comparison and contrast. So for the differences from Article 1 and Article 2, there's not much difference because both are constructive dismissal. But for Article 1, the pilot had no other choice than to leave the company because his basic salary was cut off. And for the next article, Article number 2, the pregnant woman had no other choice than to leave the company because of her pregnancy. The company's actions were designed to force the employee out of her job during her pregnancy. So the law applied for Article 1 is Section 20 of the Industrial Relations Act 1967, and the Article 2, Section 4, 1A of the Employment Act 1955. Okay, so now let's go to topic number 2. The effect of soft skill on Gen Z's industrial relation in Malaysia. So what is Gen Z? Gen Z is the group of people who born between 1997 to 2012. They are known as the Generation Z, Gen Z. They are frequently referred to as digital natives because they grew up in a world that was greatly impacted by technology. They are well known for their use of social media, digital literacy, and expanding social influences. So for this topic, the article that I choose is from the Star, Soft Skills Preferred by Employers. The link is given below. So let's discuss the issues from the article. Employers, like those mentioned by the Star, increasingly value a combination of hard and soft skills, which soft skills being crucial for success. Key soft skills include communication, teamwork, leadership, adaptability, problem solving, and emotional intelligence. These skills are often seen as people skills that are transferable across various industries and roles. So what law can be applied to this article? So the statutory law that I have chosen is the Code of Conduct for Industrial Harmony 1975. The Code of Conduct Industrial Harmony, established in 1975, serves as a non-binding guideline for employers and employees in Malaysia to promote industrial relations and maintain harmony in the workplace. So for this law, it encourages cooperation between two parties and also mutual consultation, depending on their collaboration and effective communication. Next, we look at Article 2. Also from the Star, the title is We Don't Want to Be Boss. So the link is also given below. Let's talk about the issue based on the article. So the article titled We Don't Want to Be Boss discussed the reluctance of Gen Z employees to take on the middle management roles. It highlights that Gen Z values flexibility, work-life balance, and rapid career growth through skills rather than traditional leadership structures. The article suggests that the company should adapt by offering skill-based growth opportunities and embracing innovative leadership models that give employees more autonomy. So the law that I have chosen and can be applied to this article is the Industrial Relations Act 1967, an act to promote and maintain industrial harmony and to provide for the regulation of the relations between employers and workmen and their trade unions, and the prevention and settlement of any differences or dispute arising from their relationship, and generally to deal with trade dispute and matters arising therefrom. So in this law, communication is essential to dispute resolution. Soft skills are essential in the grievance and conciliation process. So let's go for the comparison and contrast for Article 1 and Article 2. So for the differences, in Article 1, mention about the skills preferred by employer for the Gen Z. As for Article 2, the Gen Z are reluctant to take middle role management. So the difference are Article 1 mentioned about the skills preferred by the employer, and Article 2, the Gen Z are reluctant to take middle management role. So the laws apply for Article 1 is the Code of Conduct for Industrial Harmony established in 1975, while for the Article 2 is the Industrial Relations Act 1967. And lastly, let's go to the conclusion. So the conclusion is, both topics demonstrate that efficient industrial relations involve more than simply regulations. They also necessitate empathy, communication, and mutual respect. As future HR professionals, we must grasp how legal structure and human conduct interact. This enables us to design workplaces in Malaysia that are not only legally compliant but also equitable and harmonious. Thank you.